All right. Thank you again for joining us today for what is our third webinar in the Beyond Cellblocks and Border Stops webinar series, exploring policies that end ICE and police collaboration. Today's presentation is being recorded and will be available for viewing on our website at a later date. My name is Denisha Christian. I'm a national organizer with the Alliance for a Just Society, a national network of grassroots organizations working for economic, racial, and social justice. The Alliance has been working closely with our affiliate organizations to advance policies that deconstruct systemic structures of criminalization in their local jurisdictions. We are also offering this webinar series as a platform for organizers and policymakers across the country to learn from one another and generate new ideas for local campaigns that can be replicated in other places across the country as well. As the reality sets in that comprehensive immigration reform is not moving this year, we are once again faced with the challenge to continue momentum at a time where our base may be feeling worn out and perhaps even defeated. While the national landscape has been difficult to influence, we're seeing at a state and local level progressive policies that are being passed that decriminalize and humanize immigrants. Just this week, our comrades at Make the Road New York won their campaign for citywide IDs, which is one step closer to the state citizenship that they continue to fight for. This month, we are featuring a panel of speakers who are going to share some background information on detainer policies, and Alliance Affiliate Center for Intercultural Organizing will be sharing a case study on how they won and passed their legislation to end ICE police collaborations. We'll be holding a question and answer session at the end of the presentation today, although we will be accepting questions during our entire time together. So you can submit questions by going down to the message box and choose Alliance for a Just Society, and you can input your question there. All right, so joining us today, we have Nicole Brown, Alisa Wellek, and Stephen Manning. We also have the wizard, the invisible wizard behind the scenes here, who is the Alliance's own Channing Kennedy, who will help field questions and is handling the technical aspects of the webinar. So Nicole Brown is the field director at the Center for Intercultural Organizing. Nicole joined the CIO staff as Civic Engagement Coordinator in the spring of 2012. She directs CIO's field operations in Portland, manages the New American Voters Project, and represents CIO and Activists Coming Together Network for Dignity and Justice. Alisa Wellek spent the past year serving first as Deputy Director and then Interim Executive Director of the Immigrant Defense Project, where she helps guide IDP's work to fight for the rights of all immigrants accused or convicted of crime through national and local advocacy, community education, and litigation. Alisa focuses on challenging programs that entangle local law enforcement and ICE and funnels immigrants into unjust detention and deportation systems. Alisa currently leads IDP's federal reform efforts, where she coordinates a communication strategy that disrupts the dominant narrative surrounding immigrants convicted of crime and provides public education in support of legislative strategies and grassroots field operations. Stephen Manning is a partner at Immigrant Law Group in Portland, Oregon. He is a member of the Amicus Committee for American Immigrant Lawyers Association, on which he coordinates nationwide litigation strategies to advance the rights of immigrants and asylees. He has lectured widely on immigration issues and represents immigrants and their families in all immigration matters. Thank you to our panel for all of you being a part of this today. And we're going to begin now by listening to a member of CIO discuss their experiences with detainer policies. an audio clip, I believe.
I slept with her like the whole entire week because I knew she wasn't going to be with us anymore. So I slept with her, and it was going to be my first day of middle school. So I didn't want her to be gone.
Carlene is Ashley's and Brian's younger sister. She's 13 now. When her mom left, she was 11. All three are U.S. citizens. For months after their mother's departure, the children felt sad and anxious.
It just felt like a lonely, depressing, cold winter.
Brian dropped out of the job training program. Ashley and Carlene began to see a school therapist.
I was sleeping so much. And my grandma, she'd be like, "Why are you sleeping?"
I missed lots of days of school in 6th grade. I pretty much missed half of the year. I would get up from class and go to the bathroom. I'll be there for 10 minutes or more, crying. It's just not easy not having a mom with you, and when you're growing up.
The Pew Hispanic Center, a nonpartisan research organization, estimates that about 4.5 million American citizens have been born to at least one undocumented parent. Since Barack Obama took office, deportations have increased dramatically. In fiscal year 2012, the U.S. ordered more than 400,000 deportations. Expulsions like these have created a generation of what Luis Zayas calls orphans of deportation.
These are the children who remain in the U.S. after their parents are deported and in the care of someone else.
Zayas is a psychiatry professor at the University of Texas, Austin. He has a federal grant to study the effect of parental deportation on U.S.-born citizen children. U.S. Immigration and Customs Enforcement says 200,000 people deported between 2010 and 2012 said they had U.S. citizen children. But Zayas and others argue it's hard to tell just how many children are affected by deportation because not everybody reports that they have children.
Thank you, Danisha, and hello, everybody. It's a pleasure to be able to speak with you. That was just a story out of Bend, Oregon, which is a medium to small-sized town in the middle of Oregon. And I just wanted to start and share that because I believe that it just captures the voices of Brian and Liliana's children. And I think that, as the report shows, this is the story of thousands of children. And that's not to say that the deportation of folks that, of course, don't have children is not important, but I just think that story really shows the way that we're really hurting our society and tearing our families apart and hurting ourselves for our enforcement-only immigration policies. So I just really wanted to quickly frame the issue. So I believe some folks might be very familiar with it, and others might not be so familiar with the inner workings of kind of how police-ICE collaboration work. So I just wanted to briefly define a couple things. Secure communities, as you see on your slide, is an information sharing system. And so when someone's booked into a jail, whether they're convicted or not, but if their fingerprints are taken, it goes through a criminal database, and that is shared with immigration. And so essentially, if someone is flagged as quote unquote deportable, then immigration sends what is called an ICE hold or a detainer request. So we use those two terms kind of back and forth. They mean the same thing. And what an ICE hold is, it's a request. For a long time, people said it was a requirement, but it has been proven in law that it is a request from ICE to hold somebody 48 extra hours in jail. It also prevents them from posting bail. And sometimes we've seen that 48 hours become longer in certain cases. And also it's 48 hours of a business day. So sometimes weekends and holidays don't count. But essentially holding someone extra time once their charges have been dropped, cleared, or perhaps they were never convicted of anything at all. But they're being held there as an easy way for ICE to just do their rounds and pick folks up. So that is an ICE hold, and the ICE holds seem to be one of the major turning points, or building blocks of police-ICE collaboration, and is why for many of us we have zeroed in on ICE holds as a target to change, to really begin to deconstruct police-ICE collaboration. This next slide is by track. You can see, for those on the webinar, can see the abbreviation there in the bottom left-hand corner, and that's so they have just looked over the data, and I just want to point out to show that, as I said, anyone who's booked has their information shared through secure communities, and so if you look at this, these are folks that have been held on ICE holds. So 42% of them have never been convicted of anything, and if you sum up traffic, immigration violations, and no convictions at all, that's 70% of people. So 70% of the people in the fiscal year of 2013 nationally, and the numbers are huge if you begin to look at them, were not convicted of any serious crime. And largely we've been told that secure communities and other information sharing and criminal alien programs, as they call them, are to get the most serious criminals off of the street. And we can clearly see from objective data that that's just not true, and that's not the case. And instead, we're seeing hundreds of thousands of families being torn apart. So the last piece, and I'm sure we're going to get into it more, but there's some major things that we use as talking points and seem to be some of the most major issues in ending ICE holds and police collaboration, and how they hurt our community. So one major thing is community safety and public trust in our local law enforcement. We have heard stories of people calling the police because they were the victim of a crime and ending up in an ICE hold and ending up in deportation proceedings. And those kinds of stories, of course, especially if they happen so frequently, are going to penetrate through the community. And the community really doesn't feel safe to call the police. And this affects the police's ability to do their job well if victims and witnesses of crime are not going to trust them and not going to call them. And so this makes all of us less safe. Local jurisdictions end up spending their money on holding folks extra time. At least in Multnomah County, which is where Portland, Oregon is, we see emergency releases happening all the time because we do not have enough beds in our jails. And so people are with much more serious crimes are being let back out, while those who maybe haven't been convicted of anything are in immigration hold and they are being held there. And then family unity, as we said, and we heard personally in that story that children are being ripped from their families, and civil rights and due process. People are not being able to. Sometimes they're being picked up beforehand, and as we learned later in Oregon's case, which we'll get into, their constitutional rights are being violated. So that's kind of just the background, and then I'll let it transfer to the next person.
Thank you, Nicole. I appreciate that. And Alisa, I'm going to turn it over to you to talk a bit about the politics that are intertwined with this and perhaps why these local fights are so key.
Sure. Hi, everyone. Here's just a little bit of information about the Immigrant Defense Project. We're located in New York, but work with groups across the country. And we're really focused on trying to keep people out of this mass detention and deportation system, and then ensuring that for folks that, unfortunately wind up in it, that there's some amount of due process and some ability to get out of it. And I'll just say we've worked in campaigns in New York City and New York State to try to, end police-ICE collaboration, and then have partnered with organizations across the country to help with their campaigns. And so I might use a few examples of what we've done, but I kind of want to talk a little bit about some of the political context. So Nicole talked a little bit about this, but the U.S. deportation goal in 2014 was 400,000. So that's 400,000 people per year that the U.S. is trying to deport. And President Obama is now at the 2 million mark. So that's more than any other president in U.S. history. The detention bed quota is also 34,000 a year, and that's part of a congressional mandate. So no matter what, immigration finds about a person, they're required to hold 34,000 people in detention beds a year. So just to give you a little background on deportations from 1980 to 2012, I think a lot of us working in this issue I think a lot of times people doing this work, it kind of feels like maybe this has always been the case. We've always been in this era of mass detention and mass deportation. But this graph shows that, that's really not the case. And I think what a lot of us believe is that we can go back to a time where we weren't seeing, these numbers of people being thrown into this horrible system. And so if you look at this graph, it wasn't really until 1996 when Congress passed two very harsh laws that really expanded the number of reasons that people could be deported. It made it used to be that there was kind of like a limited number of convictions that would throw people into the deportation system, and then they had some ability to fight their case, and a judge could weigh the individual circumstances of their life to see if they deserve to stay in the country. And then in 1996, we see a real shift where very expansive laws in terms of who gets thrown into the system, and then taking away the ability of people in many cases to fight their deportation. And then going up on the graph, we see post 9/11, the deportation enforcement apparatus really starts to grow. That's when the Department of Homeland Security is formed, and we see billions and billions of dollars going into this deportation system. And the main way that folks are getting picked up is really through the criminal justice system, especially in later years. So we're now at $18 billion for immigration enforcement. Just to give you some context, that is the same as every federal enforcement agency combined, including the DEA, FBI, everything is less than just what's focused on immigration enforcement. And we've seen politically a real shift in terms of who's being targeted and what the Obama administration and under the Bush administration, the real focus was what they call a criminal alien. And as Nicole pointed out, one, really the government is criminalizing many of these immigrants, but, mostly folks are, being arrested for cases that end up getting dismissed or for very minor offenses. But then for folks that have more serious offenses, there's very little opportunity to ever, justify why you deserve to stay in the country and to have an immigration judge really weigh those circumstances. And another big tactic is using police as what they call a force multiplier. So this is, done in different ways depending on where you are in the country. In New York, we see stop and frisk as a huge issue that folks may have heard about, where mostly communities of color, getting pulled up on the street, stopped, questioned, frisked, and then often, thrown into our jail system where, as Nicole was mentioning, then, a detainer could be lodged and undocumented folks, could end up in immigration custody, or folks that have legal status too, like green cards, could also end up there. And then we see that's a, photo of Joe Arpaio, and in some places under what's called 287G programs, local law enforcement are actually deputized as immigration agents and, asking about immigration history and using, basically taking local resources to enforce immigration law. So I just want to give a little overview. Nicole did a little bit about this, so I won't go too much, but this is basically how they're called ICE access programs. These are these programs that throw people into the detention deportation system and how they interact with the criminal justice system. And the reason I'm going through this is because really this is where advocates and organizers across the country have been able to push back. We've seen politically a failure of any sort of federal immigration reform. And, Obama just made his speech yesterday, and we'll see what that looks like. But, right now we see that he's really, has been focused on immigration enforcement and deporting more people than anyone in history. So we're trying to think of ways, creatively to fight back and build these wedges in between the systems where police and local law enforcement end up ensnaring immigrants into the system. So these are the many ways that they sort of interact. And just to give you a sense of some of the broader context, so it's not detainers, I think, are a really key part, but there's also other ways that advocates can fight back beyond detainers. So what happens when someone's arrested, a database is searched, and police actually search for immigration law violators. So what that means is, people who may have had an old order of removal, may have been, caught at the border and sent back. That might come up, and they could potentially arrest people and bring them into custody for that. because of the Secure Communities program, which is basically a fingerprint sharing program with immigration, once you're booked at the police station, immigration will now, receive fingerprints. And for someone who's in their database, can then send back what's called an ICE detainer or hold, asking that the jail hold the person beyond when they'd otherwise be released. There's also something called the Criminal Alien Program that operates in all of the jails and prisons across the country. And that's where immigration agents are actually going to the jails and prisons and trying to interview and investigate people's status. Not everyone is in ICE's database. So say you're an undocumented person who crossed the border and maybe you've never had any interaction with ICE. The fact that at booking, often booking agents, the people that do the booking at the booking centers will ask, where were you born? And so a lot of times local jails will hand over the list of foreign-born inmates to immigration, and then they'll try to investigate what happens. And actually how that would work in New York City previously was that ICE agents would actually say that it was a legal visit. They wouldn't identify themselves as ICE agents. People thought they were meeting with their lawyers, and they weren't wearing uniforms. So someone thought they had a meeting with their criminal lawyer, turns out to be an ICE agent, and they often had people sign away their rights to fight their case, often in languages they didn't understand. And they sometimes, got information that they could then use against the person in immigration court. So that's something that I'll talk a little bit about later. It's one of the ways you can fight back against some of that information sharing. And then, once your case is resolved, the question is whether you're going to go into ICE custody or you're going to go home. And a lot of it has to do with whether the jail or the police are going to honor or submit to the detainer request. And that's where we really see advocates pushing back and really winning cases and getting people out of the criminal justice system before ICE can entrap them. So these are, this is a great map that the Immigrant Legal Resource Center in California put together of all of the different resolutions by state and locality fighting back against detainers and against information sharing between local law enforcement and ICE. And you can go to their website and you can click on it and see the different policies in each state. But you can see there's, a real pushback. And I think, politically, for the last few years, this is like where many of the successes in the immigrant rights movement have been. And it's not just kind of success in name only. This is really keeping people out of the immigration system. We see if local law enforcement, like the police or the jail, honors the detainer, unfortunately, because our immigration laws are so bad, once someone is in that detention deportation system, it can be extremely difficult to get out of it. And so really trying to build these wedges and keep people out of that system, I think, is one of the best ways to keep our families together. We think about it as really driving wedges between it. And when you think back about that little, map from arrest to deportation, there's steps at each phase where you could kind of build a wedge to prevent that interaction between law enforcement and immigration. And so I think a detainer policy can be a really great base. It's concrete. It's been done across the country. It has, so many of the kind of moral and legal arguments that you're going to hear throughout this presentation. But then there's also ways to really build other wedges in. So, in New York, not only do we not honor many of the detainers, but we stopped allowing ICE to call these, legal visits when they were meeting with people and not being uniformed. So now every person, because of this campaign here, gets a letter saying, ICE is here to try to deport you. Do you want to meet with them? And then you can choose whether you want to meet with them or not, or only with your lawyer. And so I think there are ways that we can kind of start advising people about their rights, preventing ICE from accessing that information. One of the things that we've been working on and that I know a lot of states have is not allowing police to arrest folks from just based on an immigration law violation in their database. So North Carolina and Washington instituted a policy around that. A lot of folks are saying, I think the best sort of messaging is that no detainer should be honored by your locality. And I understand politically that can, be difficult in different places, but a lot of what's been successful is putting limits on it. So saying, okay, no detainer should be honored at least until ICE, reimburses counties or municipalities for all of the costs associated, and ICE ensures that there's due process, within the immigration system, that immigrants have a right to a lawyer, and that they meet, some really meaningful standard, which, unfortunately we know they're not going to meet. And so that can be a way to really both message the work in a way that supports our longer term campaigns, but also creates a real wedge that prevents people from being turned over. So I'll turn it over to the next person, and then I'm happy to discuss some of the specific policies if people are interested.
Thank you. It's a really, really a great presentation. Nicole, I want to bring you back now to share some of the ins and outs of the campaign that you ran this year in Oregon. Can you kind of tell us the story of the fight you had?
Sure. And yes, so a few years back, and I will say Stephen, who's going to talk after me, has been in this fight with us for a long time too. But I think when secure communities started in the very beginning, and a lot of this information sharing after 9/11 even, and as of a few years back, I know, and at that time I wasn't part of it, but many activists from faith community, labor, immigrant rights activists, and legal and civil rights activists through the legal, like ACLU and whatnot, began to start to try to organize and really try to figure out, okay, what are these policies mean, and then and how can we fight it back against secure communities, etc. As those things became more and more requirements, we then chose a detainer policy as our target and as a thing that we wanted to try to push to start. We chose Multnomah County, is in the area that Portland is located, Portland, Oregon. It's, I think in many ways known to be a very progressive county, although many times when we start talking about issues of immigrants, refugees, and people of color, it's not quite as progressive as it likes to think it is. And another unique piece about Oregon's law is that the sole decision maker about detainer policies and ICE holds is our county sheriff. I believe as in King County, commissioners were able to pass a law, but in ours, we had one target, really, and that was the sheriff. That was the person we had to convince. And we could have other decision makers try to influence his decision, but in the end, it was one person who it relied on. So I believe they began by beginning to try to meet with the sheriff, with this diverse group of activists, who is the activists coming together for justice and dignity that Denisha mentioned, and just trying to start to build a dialogue with our county commissioners, who were not the final decision makers, but do approve the budget and also have a lot of influence over, of course, what happens in the county, and then also beginning to have the conversation with the sheriff. There was ups and downs. I believe we did, while we started to try to have dialogue, there was a long period of the time where the sheriff wouldn't even answer back, wouldn't say if he thought the policy was good or bad, why he thought it was good or bad. And so, essentially, we did, have to go and do some direct action. We showed up at his office a few times, outside of the county building. Also, there was quite a bit of direct action around individual deportation cases. And once he wanted us to stop showing up in his office with 40, 50 people, making him look bad, he decided to meet with us again. And then there was a county commissioner who also championed this and wanted to make a change. And so in April of 2013, the sheriff finally decided he would change his policy slightly, and he limited his detainer policy. And he said, so for folks who are charged, only for those who are charged with a Class A person misdemeanor, which is like more of a person-to-person crime, or a felony. If those folks are booked on a Class A person misdemeanor or felony, then we will honor the detainer. But if they're stopped for something very small, then they can go free, and we will not honor an ICE hold. And so we as activists, I feel like we found ourselves in this kind of weird place where we're like, well, we know this isn't really going to be enough. We know that this isn't so many people in the system, but also, trying to grapple with this half win. And we don't want to alienate the sheriff either when he did something that we wanted him to do. And so, I'd say after that point, we really organized around individual cases. We found folks that were unjustly still to expose the injustice of what was happening. We did a lot of call-in campaigns to the sheriff. And also to ICE. We were using the model that the National Immigrant Youth Alliance or the Dream Activists use, which is, putting through the Dream Activist website who the person's story is and really pressuring ICE through call campaigns and trying to get them in the media as much as possible. And use those individual stories to really raise up and show that this policy that the sheriff, has implemented, while it's, a step in the right direction, it's really, really not enough to really take care of rebuilding trust in the community and keeping our families together. And while that kind of was happening and we felt like we were feeling a little bit stagnant, we also began to consider a Trust Act, which would be a state law. Instead of going by county, it would be a state law like we see in California. I believe it's Connecticut, or somewhere out there, which I'm sure someone on this webinar knows exactly where. But a state law that would also limit or end police-ICE collaboration in every county. So we began to talk to some sheriffs in other counties, one in Washington County, which is our neighboring county, and also has a majority of both immigrant communities and a large piece of Oregon's population, and began to have those conversations.
Great, thank you. So my name's Stephen Manning, and I am here in Oregon. And there's, to kind of just carry on the story that Nicole was sharing. So Oregon had a couple very unique advantages, and we also had a couple unique disadvantages in creating this campaign against detainers. Because I am going to explain why, in my opinion, why I think Oregon is a detainer-free state and what that means. But a couple of the natural advantages Oregon had in making this happen was, one, we have a particular state law. So the U.S. Department of Justice considers Oregon as a sanctuary state. So we have a statute, it's called Oregon Revised Statute, Section 181.850. And what that statute says is it was enacted back when ICE was doing raids pre-1986. And in a very different political climate in Oregon, that statute was enacted, and it prevents any use of public monies to enforce immigration laws. So no federal immigration laws can be enforced by any state actor using any kind of Oregon public money. There is a caveat to that policy. It does allow information exchange, so the statute does not prohibit exchanging information with the federal government. And the contours of what that exception means haven't yet been, there's some disagreement about what that means and what it doesn't mean. A couple other, so that statute provides a good legal basis for many of sort of the campaign actions that took place. And as Nicole was describing, some of the other advantages Oregon has into getting to this detainer-free state was we had a really fabulous, I would say 4 points where pressure was being applied. So one was through ACT. So activists organized together in one large group, so a very broad-based group liaisoning with the sheriff of Multnomah County. We also use government actors, so our allies, both in the county commissioner's office. We use the Portland Human Rights Commission to engage in investigations. They held a hearing on the matter. We pulled in the police department of Portland. So in many states, the sheriffs go by county, and the sheriffs do not engage in what's true law enforcement. They're more corrections officers, so they run the jails. They're the ones who actually do the booking individuals. So in Portland, there's a Portland police who are actually the officers in the field. And what was happening is the Portland police were taking the rap for when they would make an arrest in the field for an individual. And that individual, ordinarily, were they a citizen of the United States, they would have been released back into the community. They were then once they made it into the sheriff's den, they were then being sucked into the deportation machine. And so the sheriff was reaping all these benefits where the Portland police was taking the full rap. And so we actually used the Portland police as well as another government actor to apply pressure on the sheriff to change the policy because it was impacting Portland's community policing model. As Nicole described, we then had direct actions for individuals like lobbying on direct cases. So that was the third pressure point. So folks who had actually been, as part of the sheriff's policy, who had actually were now in the deportation process. And then the fourth pressure point is where I'm going to talk a little bit more because that's more within my field of knowledge, is thinking, okay, we've done pressure points 1, 2, and 3. We've made some progress. We've done some education, but no one's really listening to us as clearly as they need to be. They're not paying the attention that they need to be. And so that's where the lawsuit, the legal strategy came in. And that was intended to keep the sheriff at the table, to keep the sheriff negotiating. So the legal strategy, the litigation did not come in until the end, although it had been thought about and discussed. We wanted to begin by building alliances. And then once we had those alliances built through those 3 points, if we couldn't get what we needed with those alliances, then we were going to do the litigation. There were 2 types of litigation that was brought here in Oregon. So we brought both federal claims in federal court, and then we brought state claims in state court. At the time the litigation was brought, there was a lot of moving pieces. There's litigation taking place across the country. There was a Third Circuit litigation brought by the ACLU in the Galarza case. There was a nationwide class action coming out of the National Immigrant Justice Center in Chicago. There were other individual actions throughout the country. And we weren't sure which theories were going to work and not work. And we weren't sure which forms would be better or worse. And so we brought all the claims in different forms, trying different theories. Right now, and so that's kind of where we are in Oregon right now with our litigation. And so the 2 questions I'd like to answer are, what does it mean for Oregon to be detainer-free? And then the second question I'd like to answer is, now that we're detainer-free in Oregon, what can we expect ICE to do in their counter move? Because essentially Oregon has stepped out of this detainer policy, which is the primary means that ICE used to get people into the deportation machine. Part of sharing the ICE counter moves is also taking a look at what ICE has done in other parts of the country, particularly Colorado, where very similar litigation actions have happened. And perhaps Alisa can talk a little bit about what ICE has done in New York during that Q&A period. So Oregon is detainer-free right now. So what that means is that there isn't any jail, and all the jails in Oregon are operated by the sheriffs. I don't believe there are any county or municipality jails other than temporary detention centers that could hold someone for less than 24 hours. So every jail in Oregon no longer honors the I-247, and that's the ICE detainer form. There is that doesn't mean that ICE doesn't make arrests, and that doesn't mean that ICE can't pick someone up at the actual jail at the conclusion of whatever local charge, once that local charge is resolved. But it does mean that we're detainer-free, so the I-247 is not honored anywhere. There is no statewide policy other than the state law that does not allow the sheriffs to use public funds to enforce immigration law. The policies vary from Clackamas County, which was the defendant in the Miranda-Olivares case, to the Multnomah County policy, which is the defendant in the Cabrera-Cruz case. The Multnomah County policy actually, we think, sets the standard for what the policy should be. And what that policy says is that the sheriffs will not maintain custody over any non-citizen for any immigration violation unless they're presented with a valid arrest warrant, which has been supported by probable cause, signed by a U.S. District Court judge or U.S. District Court magistrate. So no document issued by ICE itself will be honored to maintain custody of that individual after their local custody has been resolved. Being a detainer-free state does not mean, however, that the sheriffs will not exchange information with the federal government on immigration, on a non-citizen's immigration status. There's still litigation. There's still issues that we're still trying to resolve on what that information exchange means. Right now, we are pushing a theory that the sheriffs, because they're created by law, that they cannot affirmatively share information unless there's an Oregon statute or county policy that's been enacted by the county commissioners that authorizes for the sheriff to exchange that information. So they can't just unilaterally make up their mind to share information. The second is that the statute, the Oregon statute, which tracks the language of a federal statute, could be read to mean only that Oregon is only has to exchange information if the information has been requested by the federal government in a binding format. So that means if ICE has a subpoena, then they can subpoena that information, or if ICE were to enact a regulation that would require that information, then the sheriffs would have an obligation to share that information. But right now, the policies vary. So in Clackamas County, there's a policy on the books that says they will only honor the detainers when they're done through a valid arrest warrant by the district court judge or magistrate. But the policy also says that Clackamas County will affirmatively inform ICE if they, quote, suspect they have an illegal alien, end quote. And what suspect illegal alien means is going to be subject of some additional litigation in the Miranda Olivares case. So this being detainer-free right now has been good, and it has also I wouldn't say it's been bad. I don't think there's any sort of negative stuff that comes out of it. But what has happened is ICE was not expecting this at all. It sort of just happened. And the reason why it happened so quickly in Oregon is because of all the fabulous work that had been done on the ground over a course of many years. So the sort of the campaign that Nicole had been talking about really kept the local actors engaged. And then once they saw that there was money on the table, so the Miranda Olivares, the district court judge in that case, said, you know what, Sheriff, you're going to owe some money, and you're going to owe a lot of money, actually. And so let's send this you're going to get to go to a jury, and that jury is going to get to determine how much money you're going to have to pay this woman for having falsely arrested her. So you didn't have authority to arrest this person. You violated her constitutional rights. And so once that happened, because of all of these four pressure points that I talked about and Nicole had mentioned, that suddenly that ignited. And then within the span of 30 days, and probably about 50% of all the sheriffs declared that they were no longer going to honor ICE halts, probably within the first 14 days after that decision. Just moved across the state quickly. It jumped across state lines into Colorado. And so now we have these two, and now it's moving to Washington. And so throughout the West Coast, Colorado, and then parts of the East Coast, you have ICE losing one of its most critical tool in maintaining this deportation machine. Why hasn't ICE done anything national to fight back? So they're still doing their litigation. They're trying to win some of these cases in court. But right now, ICE's headquarters, their focus is very scattered. It's very disjointed. And it's disjointed because as soon as the detainer policy got flipped in Oregon and then moved to Colorado and Washington, etc., that at that same time, President Obama ordered the new Secretary of Homeland Security, Jay Johnson, to engage in a review of the deportation policy. And that was for many reasons. Lots of activism on the nationwide scale. Obama got tired of being called the deporter-in-chief, and so he said, okay, look, we're gonna look at this, and it's gonna be a process. And at that moment, the same time that ICE needed to resolve what it's going to do with detainers, it got caught up in Jay Johnson's review of deportations. And now their focus is on the border, the Texas border, with the Central American, the refugees from Central America and Mexico coming to the border seeking asylum. So right now their focus is very scattered. That's good, and that's good for a couple of reasons. So one, that allows the no detainer policy to become the norm. So that's, instead of being the detainers the norm, we've now had a period of time where no detainers is the norm, and that's good because then we can argue if they want to come back and change that, we're going to argue that they're changing the status quo, and in fact the status quo is working. So that's giving us some leverage in that regard. It's also good because we're really getting, people aren't being detained, so they're getting released into the community where they ought to be. It's also good because it's giving us additional, because these other cases are still ongoing and ICE doesn't have a nationwide strategy yet on how they're going to control the litigation, how they're going to respond. It allows us to continue to get discovery. Some of the discovery that was obtained in the nationwide, in the class action litigation in Chicago, as well as in the Galarza case, has been very effective in using in other cases. And finally, it's really good because it allows us to rack up more wins in the courts because ICE doesn't have a good counter strategy. It's bad in the sense that because there's no nationwide response, and we actually might get a good nationwide response from ICE, but because there isn't, because headquarters has been silent, we're getting a lot of local policy. Like what's happening locally depends on state by state. So here in Oregon, the ICE is divided into different districts for enforcement. Southern Oregon is controlled by this office out of Medford, Oregon, and the officers who actually run the Medford office are really, they're horrible and they're racist and they engage in a lot of really outlandish tactics. And so so we need to deal with those officers on the ground as opposed to being able to appeal to a higher authority. Whereas in Portland, we're controlled by a different district, a different region with here in Oregon, and we have stronger relationships and there are more sophisticated actors here and so as a result we have a different dynamic taking place. And so that we don't have any one person we can go to, and so that's bad. So that's the good and the bad. Now, ICE has done a couple immediate reactions. Am I on time? Okay. ICE has a couple immediate reactions. So what we've seen is, one, since here in Oregon, they won't honor the I-247, so that's the detainer form itself. ICE has tried to use these administrative warrants of arrest. These administrative warrants of arrest are arrest warrants that one ICE officer would write to give to another ICE officer so that they could go and arrest someone. Those warrants of arrest, because they're called warrants of arrest, and because if you look at the form it says warrant of arrest on it, can lead to the false conclusion that it actually is a warrant of arrest. But in fact it is not, because it's not supported by any. Normally, to get a warrant of arrest, an individual needs to have a police officer, would need to have probable cause that a crime has been committed. And that warrant of arrest would need to be obtained through a judicially neutral or a neutral third party, generally a judge. But here with an administrative warrant of arrest, it's just essentially one police officer giving another police officer the okay to make an arrest. And here in Oregon, that has not been successful. And so there's no administrative warrants of arrest that are being accepted here. My understanding is in Colorado, depending on which locality you're in, administrative warrants of arrest may be acceptable, but that is definitely one of ICE's immediate reactions. We're not sure what ICE is going to do, whether or not if they could send in an I-247, which they know won't be honored, but could they then attach a probable cause affidavit where an ICE officer would assert that I have probable cause because for whatever reason, I saw this person and I looked in their database and this person wasn't listed in our database as being lawfully here, or I interviewed this person and this person isn't here legally, or whatever it may be. Whether that probable cause affidavit will be successful. Here in Oregon, it won't be because you need to have a judicially signed arrest warrant. But we have heard of probable cause affidavits being tried in Colorado. And maybe Alisa can talk a little bit about whether that's been tried in New York. What is ICE going to do? So ICE arrests people. That's what they do. That's the skin in their game here. And so they will, what are their reactions? So we've seen home arrests. So ICE going, since they can't arrest individuals at the jail, through the detainer, through the force multiplier, they actually need to put their own boots on the ground. So they're making home arrests. Talk a little bit about, we've heard that they're making arrests at court facilities. So they'll go to the court, after the individual, the non-citizen, their charge has been locally resolved. Then ICE, we've heard in 2 instances that have been that I've been able to verify, where ICE then has made the arrest in the court, in one of the Oregon courts. ICE could get judicial warrants, so they could actually get a warrant from a federal judge. It's highly unlikely that would be possible institutionally, because ICE that's not set up, that's not part of their infrastructure. ICE can't just randomly appear before a district court judge. That would have to be done through the U.S. Attorney's Office. And right now, those systems haven't been set up for that to be possible. That doesn't mean that they can't do it, but they're going to require a little bit of a institutional change and some money and some liaisoning with other, government components, and that takes time. Finally, they could always change the regulation. They have ICE. They can write regulations that create law. There's a lot of legal issues involved, a lot of impediments for them to do that, and there's huge impediments for them to be able to change the statute. That said, President Obama does want Congress to enact some law to allow him to more quickly remove individuals who are coming from Central America who are seeking asylum in the United States at the border. Whether those changes in the rules and sort of the expedited removal process are going to allow the bad actors in Congress to also change the detainer statute is a good question, right? So we need to keep our eye on that, because that opening the statutory book can cause us, lots of things, bad things can happen there. Just a couple things, and I'm going to then turn it back over to other people, other smarter people. So ICE, the whole reason why ICE exists, they like to talk about, they have their message and they have their spin. But if you look at the statute, if you look at the reason for their existence, they exist to deport people. They exist to arrest people and deport people. And that's statutory. It's, we can have a conversation about whether anybody should be deported or not, whether we should be moving as a sort of an activist community towards abolition of deportation or abolition of immigrant detention. That's a great conversation to have. But that conversation needs to also recognize that ICE is going to keep doing it until they don't have the authority to do it. And so some of the things that we've been thinking about in terms of litigation, as well as on kind of formulating a nationwide approach to detainers and approach to ICE, is figuring out where it's okay for ICE to enforce. Where is it okay for ICE actually to make arrests? And not that we would share this with ICE, but it would allow us to say where in our activism where ICE should not be, knowing without sharing it where ICE is allowed to be, and channeling all of ICE's efforts there. And if we channel ICE's enforcement powers, which are immense and very well funded, to certain spheres, then we're going to be able to better control and better protect immigrant communities in those spheres. And just a couple of places right now. So ICE has policies right now. So I guess what I'm trying to say is I think we need to figure out where can we create space in the geography of our country where ICE is allowed to engage in enforcement actions. So a couple ideas in terms of is thinking, so no, ICE should not be allowed to do it, enforce in schools, no churches, and here's a couple, and those are right now ICE policies, right? But maybe we can also get that policy to extend it that no, it's not okay for ICE to enforce in the private home. So unless you've got a judicially signed warrant, by a district court judge that allows you into a school, into a church, you can't get into a private home either, right, to make an arrest. So no more arresting individuals for outstanding warrants, no more arresting individuals based on just because you want to enter someone's home, you need to have a judicial warrant to do that. That no place that you should be engaging in enforcement action should be any kind of public service location. So the courts, people are going to pay their utility bills. Libraries should be out of the question. If someone's playing in the park, any place that's operated for a public benefit or public purpose where individuals are come to congregate, that should be off limits to ICE, right? So any sort of public service location. And no kind of community events. So if there's going to be a protest, if there's going to be a community gathering, if there's going to be a community-wide garage sale, whatever it may be, that ICE can't engage in enforcement actions there. And where would that leave ICE ability to enforce? So that would leave ICE the ability to enforce in the workplace. So they could be using E-Verify, which is a system that exists right now. ICE could move to workplace raids again like they did in 2006, 2007. Who knows what and I will wrap up here in about 2 seconds, that raids, I don't know if they're going to come back. ICE can continue to enforce in the border zone. Where are we going to allow to do in public space? So I'll turn it back over to Danisha.
Thank you for that, Stephen, and I appreciate you picking up where Nicole left off as well. It's very insightful. Thank you to all the panelists today. We're going to open up for a couple of questions here. Channing, I know you have been monitoring the question queue.
Yeah, we got a couple of good questions in the Q&A from chat. Thanks to everyone for sending them in. Because we are short on time, we probably only have time for 2 or 3 right now. But again, this will be recorded, put up on the Alliance for a Just Society site, and we look forward to extending the conversation there and elsewhere. First question here. Alisa, are you still with us? Yes, you are. Let me unmute you. Alisa, this is a question for you. You spoke about raising up individual stories of immigrants as part of your campaign work. How can you raise up those stories or choose those stories without inadvertently reinforcing the good immigrant frame?
That's a great question. Could you guys mute your computers? Great. That's a great question. That's something that I think we worked on a lot as a coalition in New York. One of the things, the messaging that we worked on has always been to not sort of say this is a good immigrant, this is a bad immigrant, but think of ways to tell really compelling stories about people, even if they're not don't fit into a model narrative. So one thing that we did in New York was, originally there was a lot of pushback around drawing lines, around not including people with certain convictions, and our current policy still does exclude certain people, and we're actually going back for round 3 and hoping for a no detainer policy this time around, given the sort of changing political landscape here with a new administration. But we found stories that kind of from people that we work with, that kind of challenge some of the assumptions. So a lot of times, city officials were saying, well, domestic violence, survivors need the, law enforcement to honor detainers. So abusers, to protect them from their abusers. And so we had these DV survivors say, actually, this is not what we want. This is not in our name. And a lot of DV survivors who actually have, felony convictions, often related to the abuse that they suffered. So people that would be excluded from our detainer legislation, but still have really compelling stories. So I think it's often leading with the equities of the person's case, talking about family ties, talking about contributions to community, or, different things that everyone has, and including people that have a range of offenses. I think, people are more than kind of one mistake that they've had or the history of their mistakes. And we've had a lot of success in federal immigration reform too, telling pretty compelling stories of people that, have kind of more serious convictions or, haven't been here that long but have other compelling equities. And if you want to look at some examples of that, you can go to imjustice.org, IMM-Justice, that has a lot of our case campaign stories.
Alisa, can you say that URL one more time?
Sure. This is for, we did a lot of storytelling for federal immigration reform. It's IMMjustice.org.
Great, thank you so much. And then I think we have time for one more question. And actually, here's a good one. This could go for Stephen or Nicole. Nicole, let me get you back off of mute. Great, there you are. The question is, how does Portland's long history of redlining and legally enforced racism affect present-day campaigns that are explicit about race? Interesting question.
I can speak to that a little bit. Like I said, I think that that's exactly what I was trying to talk about when I said Portland thinks of itself as a very progressive place, but as soon as you start to bring in questions about race, it quickly, people just kind of avoid the issue. I'd say that I just would say that it does play out. I think, a lot of decision makers, that say, oh yeah, I totally support this. I totally support you. But getting them to speak out and to have a louder voice about how they support us, can be very hard. So, I guess it's a really short answer, but saying that that's just still a huge struggle that we have. And that when we do, and I think that one of the big ways that we see it playing out is that people are not really willing, and people with power are always say that they're supportive and never really quite willing to really talk about it and really, really be vocal about why it's an important issue and really support it that way. So I guess it's kind of a shortened answer, and I'd be happy to elaborate later if that wasn't sufficient.
Great. Thank you so much, Nicole. Denisha, I think at this point we should turn it back over to you. I think that's all the time we have for Q&A right now. Thank you so much to everyone who sent in questions. Like we said, we look forward to continuing this conversation on the internet and elsewhere.
Thank you, everyone, for joining us. Our next webinar will be on community alternatives to prisons and the criminal justice system. It'll be taking place on September 11th at 11 Pacific, 2 Eastern, and we hope that you'll join us again.
September 5th.
September 5th, thank you. Thank you, everyone.